Maybe 200 years from now, lawyers will still be talking about curtilage. Sounds like a dairy product to me, but that's another story. Mr. McNally, good morning.
Good morning, Your Honors. I'm Pat McNally of the Nashville Bar.
Yes, sir.
It's my pleasure to be here today. On behalf of Brentnol James, when you mention curtilage, it sounds like maybe a bad dairy product. Brentnol James is a fascinating individual, and not necessarily because he's 62 years old and doing a life sentence in prison, but because of his background. He was born in Guyana, South America, a country that's sandwiched between Venezuela and Suriname on the north coast of South America. At age 24, he and his sister immigrated to the United States, and they became U.S. citizens. He didn't have a lot of education, but he did know auto mechanic. And through hard work, he got his own little shop for auto mechanic and body shop work on Trinity Lane in North Nashville here. And it's a neighborhood that has a lot of stores, shops of recent immigrants to this city, to Nashville. And it might not necessarily, and because the neighborhood has a lot of vandalism and burglaries, Mr. James put up 2 signs that said no trespassing on his property. Now, it might not be a shop that we might take our vehicle to, but it was his shop, and he was proud of it. It was his entrepreneurship. It was his piece of the American dream. But it was also there where his tragedy begins. Now, my name is Patrick McNally. I am here on behalf of Mr. James. I'd like to reserve 3 minutes for rebuttal argument, please.
Certainly.
And to understand this case a little bit, and I understand you've read the briefs, but I just want to give a short summary a little bit about the background here, because it encompasses over 5 years before Mr. James ends up killing the victim, whose name is Brian Shannon Sr. And that is the name of the victim. And he and his wife and their son, Brian Shannon Jr., lived just a couple blocks down the road from the auto mechanic shop on Trinity Lane. And this started 5 years earlier, where Mr. James was the victim of an armed robbery and a shooting during it. And in fact, it was corroborated that he was a victim of armed robbery and a shooting by the police who investigated this homicide case. And Mr. James said that the gentleman who shot him was Brian Shannon Jr. And for the next 5 years, Mr. James was terrorized by both Junior and Senior. Now, there was an accomplice. There was 2 other accomplices in that armed robbery and shooting, and one of them actually did go to prison, was convicted and went to prison. Brian Shannon Jr. was never prosecuted. And Mr. James tried and tried and tried to get the police to prosecute him. In fact, he eventually filed a lawsuit against Brian Shannon Jr. for the assault on him, the robbery and the shooting. But during the course of that 5 years, Brian Shannon Sr. and Jr. had terrorized Mr. James, starting with going by his shop at times, pointing their fingers as dissimulating to shooting him. Senior telling Mr. James that if you report my son to the police, I will instruct him to kill you, to carry out his threat to kill you. And at times driving by his place doing what they call burnouts. And in fact, even on one occasion, Senior had approached Mr. James with a pipe and threatened him. And that's what leads us up to the events that brought Mr. James to trial for the homicide of Shannon Sr. That morning, Mr. James was on the street taking pictures of the Shannon home. And he was doing that for 2 reasons. One, he was posting them on Facebook talking about these people. And then number 2, he wanted to give it to the sheriff's department because they were having difficulty serving the complaint, the lawsuit that is actually an exhibit in this trial on Shannon Jr. So he was going to give him that address to show him a picture of it. Now, Mr. Shannon Sr. was very upset about this. And we know this because his wife, Monique Shannon, testified that my husband had come home from breakfast. He was upset that Mr. James was out there taking pictures of their home and putting them on Facebook, and that he then marched over to the auto mechanic shop, did not drive over there, was not entering with a car to be repaired or anything, but marched over there with the intent to assault and confront Mr. James about, why are you taking pictures of my home? Why are you posting these? Now, given the relationship between these parties, it was clear that Mr. Shannon was not an invited customer or guest to the auto mechanic shop. Now, before I launch into the trial court's error in denying the presumptive instruction, TPI pattern instruction 40.06, about a person being presumed to have a reasonable fear of imminent bodily injury or death, where another person has unlawfully or forcibly entered into their business. I want to point out something here for a second. We've all heard that standard, evaluating the evidence in light most favorable to the state, that all reasonable inferences should be weighed in favor of the state when I come up here with claims of insufficiency of the evidence. And this court and the Supreme Court has said that is a very high deference to the state. Very, very high deference to the state. I want to flip that around a second, because that is the exact same standard that a court is supposed to evaluate the evidence as to determine whether it was fairly raised for a general defense to be instruction to be given to the jury. The standard in State versus Benson, our Supreme Court, is that the evidence must be looked at in the light most favorable to the defendant and all reasonable inferences in favor of the defendant. And it goes all the way back to, I think, 1998 in this case of State versus Bolt, where Judge Tipton first enunciated that standard and has been accepted by this court and by the Supreme Court over and over again. The question is, though, how much evidence does it take to actually get to fairly raising the general defense? And in this case, it was a defense about the presumption of reasonable fear of imminent bodily injury or serious or death when a person has unlawfully and forcibly entered upon the property. And we know from Benson that it's got to be more than scintilla. And we know from Hawkins that it's less than a preponderance of the evidence. State versus Hawkins, again, a Supreme Court case. Here in this case, so again, it comes down to beauty's in the eye of the beholder. And here in this case, we know that, that there's undisputed and corroborative evidence that there was a long history between these parties. That Mr. James had been robbed and shot, and that he had said that Brian Shannon Jr. had committed this crime, that there had been terrorizing by the Shannon family to Mr. James, that Mr. Shannon is a younger man, and you can see from the video, and I would ask this court, this is one of the few times I'm actually asking the court to make sure and look at the exhibits that were introduced, and not just our description of them or the transcripts of it. It's in volume 7, it's 10 and 11. Number 10 is the one of the video of what happened, the video surveillance cameras showing what happened during the course between Mr. Shannon and Mr. James.
Can you see, I couldn't tell from reading
Yes,
what
sir.
I've read, could you see what occurred inside Mr. James' shop?
You can see he's kind of, he says he's sweeping inside his shop when Mr. Shannon's approaching up his driveway, and you can kind of see him moving, almost looking like he's sweeping. But you do see more clearly what occurs on the driveway leading up to the garage of the shop.
Had Mr. Shannon already been inside the shop when he is walking back out of the driveway?
No, I think the trial court would have granted this instruction had he been inside the shop, because the trial court said the reason that he wasn't going to give the presumptive instruction was because Mr. Shannon was lawfully on the driveway. And that's our dispute with that he was not lawfully on the driveway. But he did not go in the shop. And you can see clearly from the surveillance camera that the confrontation begins about halfway up the driveway and then finishes right where the driveway and the street are. And that's where Mr. Shannon's body is laying. But again, I talk about this high deference. I mean, when you put on those shades of glasses or perspective of such a high deference to the defendant being, to the consideration of the evidence in favor of the defendant when you're looking at whether to grant this defense or not. Here, I think the trial court has erred because, as I said before, there's undisputed evidence about Mr. Shannon leaving home angry. In fact, there's evidence that he had been consuming cocaine. It's questionable whether he's still under the influence or not. Dr. Lee, the forensic pathologist, couldn't say he was still under the influence, but did say that consuming cocaine makes one excitable, irritable, and more inclined to take risk. but he marches from his home over there with the intent to assault Mr. James to assault Mr. James about taking the pictures of his home. Now the question here goes, was there an unlawful forcible entry onto the driveway?
And that's, I guess, the part that I was interested in that you have a business.
Mm-hmm.
You have the driveway.
Correct.
And yes, he has no trespassing signs posted, but during business hours, it would seem the public would be invited onto the property to do business. Now you say, he has a beef with this one particular guy.
Mm-hmm.
He didn't post, like we have some places where they post people that aren't allowed to be on the property and they could be charged with trespass if they do. I don't get the impression that was ever done.
Correct. It was not. But, and I thought long and hard about this because I looked at Judge Dozier's analysis in Volume 5 about why he was finding there was no unlawful entry onto the property. He says because it was open to the public. And also, Mr. James testified that at first I thought it was a customer coming up. And that's who's invited to come onto the property is a customer. And then when he hears this man shouting at him, threatening to kill him, he knows it's trouble. It's Mr. Shannon. Now, let me give you an example. Would it be open to the public to come onto the property, and you'll see in the video that there's lots of cars on the lot there around the auto body shop, around the auto mechanic shop. There's lots of cars there. Is it open to the public to come on and vandalize those vehicles? No. The intent here was to commit an unlawful act against Mr. James. And given the history, it's clear that Mr. Shannon and his son are not invited on this property. They are not, Mr. Shannon is not driving up to get his car worked on. Mr. Shannon is not driving up to have some body work done. He's coming up to assault Mr. James. And that's the unlawful part of it there. Just like you would be unlawful to come onto the property to do vandalism to the vehicles that are there. And that's where I hope I'm addressing the question that Your Honor has asked. It is unlawful, and it is forcible, because we see in the video that there are arms waving. Now, Mr. James says he's swearing at me, he's threatening to kill me, he's assaulting me, and his arms are up there flailing at me. And what you see Mr. James do is come out of the garage, and he has got his gun. He does not immediately shoot Mr. Shannon. He begins wailing on him with the gun. And then the fight proceeds on down to and I will concede here that it does appear that Mr. Shannon at that point is beginning to retreat, and Mr. James then continues to hit on him. And then you see, the last thing you see before a van goes by blocking the view is you see Mr. Shannon, who's kind of down like this, almost on one knee, get up, and he kind of lunges towards Mr. James's knees. And then the van goes by, but it's very clear that shots were fired at that point, because then Mr. Shannon is laying prone on the ground there. And then the other thing I wanted to point out is that the Tennessee Pattern Jury Instruction, the criminal part of it, 40.06, is taken from the statute of 3911-611C that our legislature has passed. And in that statute, it says at the very end of it that the person knew or had reason to believe that the other individual had unlawfully and forcibly entered onto the property. And clearly, without any question, it doesn't even say reasonably believed it, it says believed it. So it's a subjective standard. And without any doubt, because of the history and because of the conduct that was occurring where Mr. Shannon's coming onto the property in an aggressive manner, marching on there, that Mr. James believed that he was there unlawfully and forcibly to do him harm. The state makes the argument that the no trespassing signs only dealt with the garage. And yes, there's some testimony by Mr. James that he did have no trespassing signs on there because his liability insurance says that people can't come into the garage. Invited customers, people who are there to do business with him, can come onto the property, can go into the office, can probably go over there and retrieve their vehicle. But if you take the state's argument that it was only to keep the people out of the garage, that's in a sense saying that, as Judge Holloway just pointed out, Mr. James would have had to wait for Mr. Shannon to come into his garage and attack him or assault him or verbally assault him before he could do anything necessarily, or before he could get this jury instruction. And as Napoleon once said, you don't do battle with the enemy when they come into Paris. You engage the enemy on the battlefield. And that's what Mr. James was doing. The state also says that even if the instructions should have been given, even if there was sufficient proof of an unlawful, forcible entry onto the property, that it was harmless error. And it is not harmless error. This was the real thrust, the real core of the defense theory. And in the Faulkner case, it talks about how when you have the state's theory, or when you have the defense theory of the case, there should be an instruction given so that the jury is properly instructed with a charge as to all the legal and factual issues that arise in the case. State versus Garrison says that again, the defendant is entitled to a complete and accurate charge of the law, so each issue of fact is raised by the evidence will be submitted to the jury upon proper instructions, including self-defense or defense within your own home or business. And really, I go to the importance that this court and the Supreme Court has put about jury instructions. Over and over again, we're told that the jury is presumed to be following the instructions of the case. And great reliance is on the fact of that presumption. Here we're asking that Mr. James be given that presumption and that defense theory of the defense be presented to the jury. It would have made a difference if the jury had been told that he was presumed to be acting reasonable, to presume to be able, to presume to believe that he was in fear of imminent bodily injury or death when Mr. Shannon marched onto his property. I would also like to address for a moment how Mr. James was not free from excitement or passion enough to be able to commit premeditated murder. He is convicted of premeditated murder, first degree. But when you look at this case, you see that there's this prior relationship between the parties. Okay, well, there's several factors that the courts have said we can look at. The prior relationship between the parties, the defendant's declaration or any declaration of intent to kill, any kind of planning, putting something together, the manner of the killing, and finally the defendant's demeanor or calmness after the fact. We'll start from the very beginning. Mr. James did not arm himself and go march over to Mr. Shannon's home to commit murder. Shannon brought the fight to Mr. James. Shannon came up on his property with the intent to insult him, to confront him. And Mr. James, who legally was carrying a firearm, and the courts have said in State versus Compton as well as State versus Jackson, I think the other one, simply being armed is not does not evidence an intent to commit to premeditated murder. Mr. Shannon brought the fight to Mr. James. Number two, there is no declaration of any intent to kill Mr. Shannon. In fact, Mr. James was trying to get the law enforcement to help him and was going to sue his son for the assault that occurred upon him. He was using lawful means to get compensation. There's no evidence of him planning any attempt to commit murder of Mr. Shannon. And finally, the last thing I really, really want you to think about is what was Mr. James's demeanor and conduct? And I'll go into my rebuttal here because this is really important. What was his demeanor and conduct after the fact? Officer Evans, who was one of the police officers that took Mr. James and put him in the back of his patrol car, said he seemed to be terrified. He was terrified that somebody from the Shannon family was going to try to hurt him. And then look at exhibit number 11 in volume 7. This is the video recording of Mr. James's interview with Detective Williams hours later. He is so animated. He is so full of passion. He's up and yelling. His hands are flaying when he's answering the questions from the detective. And the detectives, to their credit, seem to say, okay, we get it, you know. He is so animated, so upset, that it's very clear that he hasn't even calmed down yet from what has occurred in there. Now, the state will say, well, you know, he did say, in response to the question by Detective Williams, how would you feel if Mr. Shannon dies? Because at this point, it's one of those trick questions, you know, they haven't told him that he passed away yet. And they said, how would you feel if he died? And his response was, and it's awful, it's hostile, that I wish he was dead. I wish his wife was dead, his kid was dead. I wish all of them were dead. I mean, it's hostile, but it is not showing premeditation to go out and kill anybody. It's a rationalization of what he has done, and it's also still inflamed passion about this whole 5 years of hostility that's been going on by these people. This is one of the cases that I would ask you to look carefully at his passion and excitement hours later during the interview to see that there was never any moment of separation between that encounter by Mr. Shannon, the striking of him with his gun, and the eventually shooting him.
And Mr. McNally,
Yes, sir.
I guess the problem, I shouldn't say problem, but what we're faced with is all this was brought to the attention of the jury
Yes, sir.
to consider. His demeanor after the fact, the officer's testimony, and they found that he premeditated.
Yes, sir.
So, you know, that finding by the jury is pretty compelling.
It's a high deference that I was talking about a few moments ago.
Yeah.
Flip that around and give me my jury instruction. Send it back for that jury instruction, because I think if he had gotten that presumption, it would have been a different outcome. I'm not saying he would necessarily have been self-defense, but it certainly could have been a non-premeditated murder. I agree with you. It's a very high deference. But there is no way anyone can look at his interview and look at Officer Evans's testimony and say this man has calmed down or this man is free of excitement and passion at the time after the fact. And it's pretty clear from the looks of the wailing, the beating, and then the shooting that he's very excited. He's very, you know, he's overwhelmed. Thank you. I've slid into my other part of the time, but I appreciate the opportunity.
Thank you, Mr. McNally.
You're welcome.
All right, General Lundy.
Thank you, Your Honor. Again, my name is Will Lundy. I'm an Assistant Attorney General, and I represent the state of Tennessee in this appeal. And the state asks this court to affirm the defendant's convictions. And I want to start with the premeditation piece. There are other factors that can be considered when we look at premeditation. First of all, failure to render aid. As you know, when you look at the video, there's no question that the defendant shot Mr. Shannon and walked away. There was no attempt on his part to render aid. Second, another fact that can be examined is shooting the victim after he had turned to retreat or escape. And I think, you know, this is a very important piece when we start looking at the video and evidence in this case. The video evidence is very clear. And what happened was, and my friend talked about how Mr. Shannon flailing his arms, and that's not exactly what the video shows. What the video shows is that Mr. Shannon walks up onto the driveway. Mr. James appears in the doorway of his shop and comes out. Mr. Shannon does a number like this where he kind of points back towards his house, ostensibly to ask, "Why are you taking photographs of my house?" He makes a motion like this, pointing at the defendant. He turns and starts to run away, or at least walk very quickly. He is very clearly trying to escape. The defendant chases him down in the driveway. Mr. Shannon continues to run. The defendant chases him down, beats him over the back of the head with the gun until he knocks him down to his knees, and then when that white van obscures our view, he shoots him in the head twice. Repeated blows can demonstrate premeditation, and here we had repeated blows. And we also have a motive. Mr. Shannon very clearly Mr. James clearly hated Mr. Shannon. He said that Mr. Shannon should be dead. In fact, he said that Mr. Shannon's wife should be dead. He said that his mother should be dead. He said that his whole family should be dead. He called them dogs, and he said that if Mr. Shannon lived, he'd kill him again. As to the defendant's argument about the state of passion, Again, as you pointed out, Judge Campbell, the jury rejected those arguments. The jury rejected this idea that the defendant was in such a state of passion that he was incapable of forming the intent to kill, or incapable of premeditating the murder. When you look at the defendant's testimony, as he describes how this fight sort of goes down, based on his own testimony, what he's talking about sounds very reasonable, very rational. He's seeing this person who approaches him. He walks up to him. He has his gun, but he doesn't really point it at him. He backs up at one point, and he sees Mr. Shannon circling around him, and in his own self-defense, eventually he starts to hit Mr. Shannon. He claims that Mr. Shannon doesn't run away until he starts hitting him. And so as the defendant, and then he claims that that firing the gun was completely an accident. He had beaten him over the head, and that was in an act of self-defense. So when we take the defendant's testimony, there's nothing that the defendant says that would indicate that he was in such a state of passion that he was incapable of forming the requisite intent to kill. And again, as you pointed out, the jury simply rejected that version of the events and rejected this idea that the defendant was in such a state of passion that he could not form the requisite intent. Moving on then to the jury instruction. And I want to look at my notes to make sure I remember everything. First of all, I want to dispute that Mrs. Shannon never said that Mr. James intended to go over to, or that Mr. Shannon intended to go over to Mr. James's property to assault him. She said that he went there to confront him, which is very different than an assault. We can have a confrontation without having an assault. So she never did say that was his motivation. I do agree with Mr. McNally that we do have to look at this when we're talking about the jury instruction in the light most favorable to the defendant, just as on the flip side when we're talking about sufficiency of the evidence, the light most favorable to the state or to the verdict. So when we look at what happened here, the question is ultimately whether Mr. Shannon entered the business unlawfully and forcibly, and it has to be both before he's entitled to this jury instruction. And so, in order to enter unlawfully, as counsel pointed out, these no trespassing signs weren't up with regard to the driveway, and as the court pointed out, this was a business that's open to the public. There's no reason to believe that as a customer I couldn't walk onto the property and tell Mr. James, hey, my car is rusty and I would like you to do some body work for me.
But obviously Mr. Shannon wasn't there for business.
Right, Mr. Shannon wasn't there for business, but that doesn't necessarily mean that his entrance onto the property is unlawful. And, there's no evidence that there was a restraining order. There's no evidence that he was otherwise legally prevented from being there. And again, the no trespassing signs might get us there, but as far as that goes, those signs applied. They were posted insofar as they were posted. They were posted on the defendant's building, and for the reasons that counsel explained.
For insurance.
Yeah. Excuse me?
It was for insurance.
For insurance purposes, that's correct. To keep people out of the bays, we don't want cars falling off of racks and hurting people. So that's why they were there. As far as the unlawfulness, let's assume, again, taking the evidence in the light most favorable to the defendant, that Mr. Shannon indeed assaulted Mr. James when he was on his property. The problem is that the jury instruction talks about the entry itself being unlawful. So what was it about his entrance onto the property that made it unlawful? Certainly if one goes onto the property to commit vandalism, the vandalism is unlawful, but that doesn't make the entry itself unlawful. We see similar things when we talk about burglary. If a person enters a house or enters a building lawfully, but then intends to commit a crime or commits a crime in the building, there's a distinction in the analysis between the entry itself and the actions that are committed in the building or on the property. And that's what we have here. And so there's simply nothing in the record that would suggest that Mr. Shannon was legally precluded from being on the driveway, which is what would be necessary in order for him to enter unlawfully. And moreover, he didn't enter forcibly. And, again, we have to look at this in the light most favorable to the defendant. And, the defendant talks about how, Mr. Shannon comes onto his property, he's yelling and screaming. But Mr. James didn't know that Mr. Shannon was in his driveway until he heard him yelling and screaming. So Mr. Shannon enters the driveway before Mr. James even knows that he is there. So then the question is, does that constitute the kind of forcible entry onto the driveway that would make it forcible under the statute? And it doesn't. So the question is whether by means of physical power or physical force, he compels his entrance onto the defendant's driveway. And counsel argued that perhaps, under my interpretation, there's simply no way for a defendant ever to receive this kind of instruction if we're talking about a driveway versus a building. And I think the instruction kind of has buildings mostly in mind. But if you will, imagine a scenario where Mr. James is outside of his building when Mr. Shannon approaches. And Mr. James stands at the edge of his driveway and says, "You can't come any further. You are not allowed on my property." Mr. Shannon then approaches. And then, and any entrance onto that property at that point, I think, would be unlawful. He's been told not to go on there. And so now if he does manage to get on, that would be unlawful. So imagine Mr. Shannon then either physically pushes Mr. James out of the way and physically, makes him fall back in some sense. And even if that's, under Allen, which is the case that counsel cites in his reply brief, even if that's pointing a gun at Mr. James. So imagine Mr. Shannon stands there and he is yelling and screaming and he points a gun at Mr. James and Mr. James backs up, and at that point Mr. Shannon comes onto his property. Well, now he's entered the property both unlawfully and forcibly. And we simply don't have either of those things there because Mr. James didn't even know exactly when Mr. Shannon came onto his property. And even if the court were to find that Mr. Shannon did unlawfully and forcibly come onto the property, even if the court were to find that this jury instruction should have been given to the jury, I would argue that it is, that it is simply harmless. And the reason for that is that even if Mr. James's belief that he's in danger of great bodily harm, even if that is reasonable, he still has to use reasonable force under the circumstances. And the jury watched the video. The jury watched as Mr. Shannon turned to run away. The jury watched as Mr. James pursued Mr. Shannon down the driveway and beat him over the back of the head with his gun until he was on his knees on the ground, bleeding and basically helpless. And they watched as the van passes in front, and then the next thing they see is Mr. Shannon lying there, as far as they can tell, dead on the ground. He didn't die until a little bit later, but he was absolutely helpless and had clearly been shot in the head. The jury saw those things, and because the jury saw those things, they would not have believed that the defendant's actions under the circumstances were reasonable. Mr. Shannon had turned to retreat, and the defendant chased him down and executed him in the driveway. And for those reasons, the state would ask this court to affirm Mr. James' convictions. And if the court has no further questions for me, I will cede the remainder of my time.
All right, thank you, General.
I forgot to mention that one of the best pieces of evidence that Mr. James was not in his right mind or free of excitement and passion was the fact that his brain was hijacked during this incident. And the reason that we know that is because during the interview with Detective Williams, Detective said, "How many times did you fire the gun?" And Mr. James said, 10 times. 10 times. And then he said maybe 12. And we know, undisputed, that only 2 casings were found at the scene, and that only 2 shots were that Mr. Shannon had only suffered 2 bullet wounds. 2 is still a lot, but it's still unfortunate. But to sit there and say it was 10 or 12 different times I fired my gun, with no reason whatsoever to embellish the situation, shows that his brain was hijacked during it. He wasn't thinking straight at all. What happened here partly is exactly what Judge Tipton warned back in 1998, was that the trial judge began to weigh the credibility of the witnesses. And Judge Tipton, when he set that first standard about all inferences drawn in favor of the defendant, the evidence in the light most favorable to defendants, he also wrote that the reason that this was such a high deference for the defense is that because it would be improper for a court to withhold the defense from the jury's consideration because of judicial questioning of any witness's credibility. And if you don't get into credibility contests between the state's proof and the defense proof, this jury instruction under the State versus Benson should have been given, and given the presumption that Mr. James was acting with a reasonable belief that he needed to conduct himself in the way he did. And I go back again to the very fact that the instruction as well as the statute says, knew or had reason to believe that an unlawful enforceable entry had occurred. Given the history between these parties of 5 years of terrorizing, it's clear that Mr. James had plenty of reason to believe that there was an unlawful enforceable entry on his property to do him harm. Thank you, sir.
All right. Thank you, Mr. McNally. Well briefed, well argued. I think we've got plenty more cases this afternoon, so let's take a lunch break.
All rise.
1:30.
Yes, Your Honor. This court is now in recess.